Sarah. The Honorable, the Judges of the United States Court of Appeals for the Fourth Circuit. Oyez, oyez, oyez. All persons having any manner or form of business before the Honorable, the United States Court of Appeals for the Fourth Circuit are admonished to draw nigh and give their attention, for the court is now sitting. God save the United States and this honorable court.
You may be seated. Winograd.
Thank you, Chief. Thank you, Judge Gregory, and may it please the court. This case presents a number of questions, the first and most important of which is whether the agency erred in finding that authorities in El Salvador are able to control MS-13. I will, of course, address the question on which the court sought supplemental briefing, but I do want to be clear that even if the court disagrees with everything we say in our supplemental brief, we believe we should still win this case based on the arguments we made in the original briefs. And if the court agrees with those arguments, it can leave for another day the arguments raised in the supplemental briefs. Now, at the outset, I would like to address a threshold issue that often gets overlooked in cases like this, which is how we should be measuring whether authorities are able to control a private actor or organization. Because no society is 100% crime-free, we of course concede that the mere fact that a gang or private organization is able to persecute an individual on one occasion does not by itself show that authorities are not able to control it. But by the same token, the fact that authorities respond to one particular incident does not show that authorities are able to control it. So in our view, to ask whether authorities are able to control a gang is to ask whether, as a general matter, they can prevent or deter the gang from terrorizing or persecuting people in the applicant's position. So by analogy, if we were asking whether a teacher could control his or her classroom, the fact that a child threw a paper airplane on one day would be no more dispositive than the fact that the teacher sent another child to the principal's office on a different day. Those would simply be data points. To actually answer the question, you would have to observe the class for a period of time and measure the amount of time the teacher spent teaching versus the nature and number of disruptions by the students. If you prefer a football analogy, if you wanted to know which team controlled the line of scrimmage during a game, you couldn't simply watch one play. You would have to watch the entire game and then look at the statistics the next day. And so too here. Asking whether authorities are able to control a gang requires an overall assessment that focuses not simply on any one incident, but on the government's general ability to control a gang. So here in the United States, for example, MS-13 operates in many cities, and it's been responsible for the murders of innocent civilians. But no one would say that authorities in the United States are unable to control MS-13 because the gang is not able to terrorize the general population in the same way that they do in El Salvador and other Central American countries.
Counsel, how does those analogies are interesting, and I'm trying to think them through, but I have a question about how they apply given that we do have a finding and the standard of review that we look after. I mean, so your analogies, seem worth considering, to the fact finder, perhaps as that determination is made. But once the determination is made, don't we still apply the clear error standard of review on this?
Well, yes, substantial evidence in the agency context.
Right,
Certainly, yeah, we don't dispute that the ultimate finding is subject to substantial evidence, but I would make 2 points. One, it's substantial evidence based on the record as a whole, and evidence is only as good relative to its weight to the countervailing evidence. That's why Lady Justice is holding a scale. So, we can't just look at the facts on which the immigration judge mentioned. We have to look at the record as a whole to see whether the record as a whole is supported by substantial evidence. And also,
isn't it slightly different than that? Isn't that we look to see if the evidence as a whole compels a different result?
Yes, whether the evidence as a whole compels a different result. And the other point I was going to make is, as you, Your Honor, noted in North of Grumman in 2019, substantial evidence review is not simply a rubber stamp. So even though it is deferential, it is not a rubber stamp. Now, as to the arguments that we made in the original briefs, the first was that the agency conflated authorities' willingness to control MS-13 with their actual ability to do so. And we think that's legal error that's subject to de novo review. Now, the IJ cited two reasons for finding that Salvadoran authorities can control MS-13. One, the police came to the scene of the murder in question and started an investigation. And two, they provided security at the funeral a few days later. But again, just as sending a student to the principal's office on one day doesn't show that a teacher can control their classroom as a general matter, sending a few police officers to the scene of a murder or the resulting funeral doesn't show that Salvadoran authorities can control MS-13 as a general matter. At most, it shows that they are willing to control MS-13, but being willing to control a private organization is simply a different question from being able to control a private organization.
Why does the funeral example not illustrate ability? The fact that there were no despite a threat that no men should go to the funeral, men went to the funeral, authorities came, and there was no incident.
Well, the funeral at most could have lasted a few hours. So if my clients were eligible for 24-hour police protection, sure, we would concede that having that protection there, they would be able to prevent the gang from attacking them. But my clients, no one except politicians and whatnot are eligible for that kind of protection. So the mere fact that the police were able to prevent that MS-13 did not attack the funeral where police were present, I don't think that shows that as a general matter, if my clients returned to El Salvador, that they would receive comparable protection. Now, we think that to resolve the ability question, the IJ should not have focused just on these incidents, but on the evidence and record as a whole, including my client's own testimony. And that leads to our second argument, which is that the IJ ignored virtually all of the evidence in the record. So to begin with, the IJ made no mention whatsoever of the expert declaration, which said that MS-13 is challenging the Salvadoran government for primacy, made no mention of a State Department report which said that the police are often hampered by inadequate funding and limited resources, and made no mention of a report from the Canadian government which said that gangs have infiltrated many state institutions, including the National Police. And that evidence corroborated my client's own testimony, which the IJ found credible but didn't mention, that the members of MS-13 who threatened to kill him and his wife specifically said that they had sources inside the police station who would tell them if he cooperated with the authorities. So, as this court said in Portillo Flores, the agency abdicates its responsibility when it completely ignores this kind of evidence. So we think at a minimum, yes.
Counsel, don't we look not just at the IJ, but the board's decision?
You do look at both, although in this case I would note that the board adopted, not simply affirmed, but adopted the IJ's decision at its own.
But then it went on and gave additional reasoning, and on your point, it specifically said that it found that specific information, I agree, I understand you challenged the sufficiency, it sounds like, of that information, the local information it cited, but it compared that against the general information. So at least at the board level, the evidence you talk about was addressed, wasn't it? It may not be as fulsome as you would like, but it's addressed.
Well, this court has said on many occasions that substantial evidence review requires the fact finder to build an accurate and logical bridge between the evidence and their conclusion. Here, we don't think there was any bridge that was simply built. It was the board simply said, we're not persuaded. I don't think that is not providing reasons in support of their determination.
It says that specific evidence outweighs the general evidence. I thought, maybe I got that, maybe I'm not remembering that right.
Sure, we just don't think that is a sufficient explanation when considered on the record as a whole. We don't think, I mean, even if the board said that, we don't think that any reasonable adjudicator could make that conclusion when all the evidence as a whole was considered. Now, because we think we should prevail under this court's existing precedent, We don't think the court has any need to consider whether it can or should revisit that precedent. But if the court wants to do so, our position would be this. This is what we would ask it to hold. The unable or unwilling test does not come from the term persecution, and it is not a standalone extra-textual requirement. We believe it actually comes from the part of the refugee definition, the requirement that a fear of persecution be well-founded, and the requirement in the withholding statute that the non-citizen's life or freedom would be threatened. So we think,
Counsel,
yes.
before you give, I appreciate the argument, I'm interested in it, but am I correct that we can't overrule another panel unless something has happened that calls us to? So it seems like you're getting straight to why we should look at that with a clean slate without addressing how Loper Bright, compels that. So maybe I think we need that link.
Happy to provide it.
Yeah.
Sure. So because the Supreme Court has overruled Chevron, we think this court is free to revisit any prior decision in which the panel adopted an agency's interpretation of a statute without exercising its own independent judgment. And we think Loper Bright is not to the contrary. In the paragraph in question where Loper Bright said that it was not calling into question prior cases that relied on Chevron, the Supreme Court could have only been referring to its own cases and not circuit court cases.
But didn't the first question whether our precedent deferred to the agency under Chevron, whether or not it overrules that, the first question is whether our precedent was Chevron deference cases. And I don't, looking at the cases beginning with M.A. and Crespin and Milani, I don't see that any of them on this issue, maybe tell me if I'm wrong, I'd be interested in your views on that, how any of those give Chevron deference to the board.
Sure. Well, I believe, M.A. went on bonk, as does Lopez Sorto, so I'm not sure those panel decisions are still precedential. But looking at Miliani, which seems to be the first time that this court squarely considered the question, we acknowledge that Miliani did not explicitly cite Chevron, but nor did the court exercise its independent judgment. We think Miliani went even beyond Chevron by treating the board's interpretation as though it was itself binding, almost like vertical stare decisis in reverse. And we also think there's some tension between Miliani and Portillo-Flores, because while the former identified the term persecution as the source of the unable or unwilling requirement, Miliani did, Portillo-Flores treated them as entirely separate elements. So we think there's also some tension between there. Now, I will grant you that at no point has this court said we are deferring to the board under Chevron on this issue. But at the same time, it seems clear that this court was not doing its own independent work that what the Supreme Court anticipated said courts should be doing, what it said in Loper Bright, what they should be doing. It was not going through the tools of statutory construction. It almost reminds me of the idea of federal general common law that the Supreme Court rejected in the Erie Doctrine. It originated with the agency, of course. I'm not saying it's a judge-made doctrine. Here we have an agency doctrine. I don't think there's any dispute that the unable or unwilling test originated with the agency. And then I think it just, courts kind of, if not deferred to the agency, almost acted as though they were bound by the agency, as though they had no choice but to adopt this requirement.
Well, it's interesting. As you point out, none of those cases say they're deferring. In Crispin, is an interesting case because there's an example where we expressly do that on the definition of particular social groups. So when we follow Chevron deference, we know how to do it and we do it. It sounds like what you're saying is that even if we haven't employed Chevron deference, we should revisit prior opinions that refer to other circuits, refer to our precedent, refer to the act, refer to board decisions to be sure, but I don't think Chevron said you can't do that from a persuasive standpoint.
Sure. What I would say is this, is just as when Chevron was still good law, there was no magic words requirement. Court said that agencies did not themselves have to cite Chevron in order for their opinions to get Chevron deference. I think The same would apply with this court's case law. Just because this court did not explicitly cite Chevron or Brand X, I think if it is clear from the opinion itself that it was following the lead of the agency rather than taking the lead, then it should be read as a Chevron-style opinion. Yeah. With my remaining time, if I could just turn to the ineffective assistance claim. Now, if the court agrees with us on the unable or unwilling issue, then it would only need to agree with one of our remaining arguments, the first of which is the ineffective assistance claim. And we argued that the prior attorney provided ineffective assistance by failing to file a separate asylum application on Coney's behalf, the wife. The government does not really dispute that claim. Their entire argument is contained in a footnote, which simply repeats the board's assertion that the prior attorney made a strategic decision not to seek asylum for Coney. But the government doesn't make any attempt to explain what strategy prior counsel was ostensibly pursuing. And if you look at prior counsel's own explanation, it was based on the mistaken belief that asylum can only be granted if a non-citizen was subject to past persecution, as opposed to simply having a well-founded fear of future persecution. But that's not the case. Under the plain text of the statute and the regulations make clear that non-citizens can be granted asylum solely for having a well-founded fear of future persecution. And even if gang members' threats to kill Coney were not enough to qualify as past persecution, which they arguably were under this court's precedent, I think they were certainly enough for a reasonable person in Coney's position to fear that she would be subject to future persecution. In fact, the very expert whose declaration prior counsel submitted specifically said that the gang would target both Brian and Coney if they were removed to El Salvador. And because Coney herself did not witness the murder, the only reason the gang could have threatened her was because she was a member of Brian's immediate family, which under this court's precedent is sufficient for an asylum claim. The court has no questions at this time. I'll reserve for rebuttal.
Thank you, Mr. Winograd.
Thank you, Your Honors.
Mr. Shikari?
Good morning, Your Honors.
Morning.
Spencer Shukard for the United States. May it please the court. A lot of ink has been spilled over this case over the last couple of years. And the scope of the case has been sort of greatly expanded in that time. So I think it's important to reemphasize that this is a straightforward case, that the agency wins on the merits. It doesn't take much effort for the agency to win, and Loper Bright doesn't change that. And I know in my answering brief, I argued that the state action, unable and willing element kind of disposes of the whole case, and it does, but given the intervention here of Loper Bright, I wanted to point out an alternative path where we can kind of avoid all that altogether, which is nexus, which takes care of the merits and the motion to reconsider, and then competence, which deals with the motion to reopen for ineffective assistance. And dealing with the case that way, we don't have to touch Loper Bright at all. It just is an overcomplicating issue that we don't need to get into.
Why is that? Okay. Are you suggesting that's the way the government would prefer us to resolve it?
I would prefer you resolve it in our favor, however you'd like to do it. If you'd like to have us win on every point, that would be fine. I'm just trying to offer you a path of least resistance here. And I'll start with nexus, if you're agreeable with that.
Do you still maintain the position in your supplemental brief that Loper Bright does not have an effect on our prior precedents concerning government's unwillingness and unable to control
Yes, sir.
these? Okay.
I can start with that if you prefer.
Is your argument, go whatever you want to do.
I will start with nexus. Nexus is a legal holding. Obviously, it's reviewed de novo, but it rests on facts. They don't immaculately appear out of the ether. And those facts have to be found. And one finding that always has to be made for nexus is the motive. IJ made a motive finding here based on the facts. He found no motive to a protected ground, so there was no nexus. The board adopted and affirmed that. And the facts are pretty terrible here for the petitioner. Everything that the gang did, it did to prevent the petitioner from going to the police. It didn't know that he had already called the police because he did that anonymously. So his first involvement here is when he is seen watching the shooter run away. So all they know about petitioner is he saw the shooter. Everything they do from that point is to prevent him from going to the police about it because they don't want to lose any more gang members. They tell him not to go to the funeral. He does. They're telling him they're watching the police station. They call him. The gang leader hems and haws about how he doesn't want to lose this gang member or that gang member, and eventually says, I can't have you around. You got to get out of here. And he goes. Never mentions the family connection. Never mentions anything to do with the extended family. It's all just about the incident that night and him having witnessed it. That is substantial evidence in favor of the nexus finding. And
Mr. Schubart, your colleague says that the BIA applied the wrong standard in reviewing this finding. What do you say to that?
the board adopted and affirmed the immigration judge who applied the facts to the legal standard. So what petitioner is doing is reading that one particular sentence out of context where the board says, we find no clear error in the IJ's nexus determination. Nexus is the legal standard, but in context, what we know is that the IJ applied the facts to the law, which is what he's supposed to do. And then in the next paragraph, the board describes what it's talking about. It's talking about motive, and it expanded on that again in the analysis of its motion to reconsider. It says, yes, we know this is a legal standard, but what you were talking about was motive. And indeed, in petitioner's merits appeal,
If we were to disagree with you and we were to find that the board applied the incorrect standard of review, what would be the appropriate remedy?
that's legal. You would have to send it back for the board to apply the correct standard. It wouldn't be reversal, it would be remand. Because again, these facts are terrible. That's why the petitioner is making all these broadsides.
Wasn't there a finding on independent grounds?
A finding on independent grounds. You mean, you're talking about broader than nexus?
Yes.
Yeah, sure. There's also the unable, unwilling, which was the main focus of our brief, and I can move to that if you like. So, in this case, petitioners have to prove that the government would not or could not protect them from the people that they fear, either in the past or the future. In this case, we know exactly what would happen with these exact police, with these exact petitioners in these exact circumstances. It's a very rare set of facts that we have. Typically, when we're relying on country conditions evidence or other evidence, it's because we're trying to read the tea leaves to actually come to this conclusion. But here we have a perfect snapshot of what happens. We know what happens when they call the police. They arrive and they assist. That's exactly what you want from your police. And again, the facts are not great for the petitioner here. He hears a gunshot, he calls the police, the shooter runs away. There's a threat not to go to the funeral. They call the police arrive and provide protection, the gang doesn't show up. Afterwards, the gang says, don't go to the police, we're watching the police, don't talk to the police. Every bit of direct evidence that we have in this case suggests that the bad guys don't like the cops, they're afraid of them, and that the good guys want the cops around. That's the best evidence you're going to get. Petitioner's analogies don't really make sense in this context. He's asking the court to ignore the direct evidence in favor of this generalized evidence. That's what the agency did, I think, in Portillo-Flores. Because
So, counsel, your position is that we don't have to look at country conditions at all because they came to the crime scene and showed up at a funeral. That, in other words, we can just ignore the out-of-control chaos with the gangs in that country just because of those two, as I think your colleague said, data points. Data points that did specifically relate to this case, but you're saying because of that, whatever the country condition is generally in terms of control is irrelevant. Is that your position?
No.
Or is it, I didn't think, well, it sounds like that's what you were getting to.
No, what I'm saying is we want to use the direct evidence as give it primacy in the analysis. The immigration judge didn't ignore the country conditions evidence. Petitioner said...
But it didn't, did he give any attention to the reports, the Canadian report, UK report, American University, and those experts?
He didn't. Petitioner was just arguing that evidence corroborated what he was saying, and the IJ actually made that finding on JA 222. That was part of his credibility finding. So he indicated that he had read the country conditions evidence and that it did generally corroborated that they were being truthful. But their belief about what the government is going to do to them is not something that he can take as fact. Fears don't create
Your
facts.
position with respect to the IJ is because because the judge found the petitioners credible, that indicates the judge considered the country condition evidence?
He said he did. So that's what indicates that he considered the
He said
evidence.
it, okay.
Yes,
I
he
thought-
said that
I
the
remember.
country conditions evidence is corroborating more or less what they're saying. That's why they're credible. That's on 222.
What's the side of that?
222.
Okay.
So, and typically when the agency gets in trouble in these unable or unwilling findings, what they're doing is kind of putting aside what the petitioner says about what the police did for them. Usually it's nothing. It's token assistance, as in Oriana v. Barr. And looking at the country conditions and saying, oh, this looks fine. It's good enough. That's directionally the error that happens. That's what happened in Portillo Flores. Whereas in this case, the agency did exactly what courts typically want them to do. They looked at the exact evidence, what happened to this petitioner. These are fact-specific cases. So we know what would happen to them because it already happened. Every time they called police, they were safe. This is exactly what you want from a country. And the country conditions evidence does not show, respectfully, Judge Gregory, that it's completely out of control. It shows that El Salvador struggles with these gangs, as a lot of Central American countries do, but not that they have succumbed to gangs. They don't have to be perfect in order to be willing and able to control their to protect their constituents from these gangs. This is what happens. The kind of thing that happened to petitioner could happen anywhere. It doesn't mean the countries are unwilling and unable to protect their citizens. So, but petitioner wants us to kind of undo the way that the unwilling and unable element works using Loper-Bright. But as I said in my brief, that doesn't work. Loper-Bright has no effect here. One, because as you were talking about earlier, the court never has deferred. Loper-Bright is about deference. No more mandatory deference, but that has never happened here. Going back, the earliest case that I could find using the words was MA, the case you mentioned. That case did go back to the agency, came back up and went en banc. And they gave a different holding, but it was because there's a special status that Army deserters have under the United Nations protocols. And the court didn't want to weigh in to the political question of how a country should characterize the atrocities of a renegade army on its own soil. It was a very niche issue. It didn't actually dislodge the unable and unwilling finding that they had made previously. And the same, and by 2000.
Just to follow up on that, I mean, if our court rehears a matter in bank, and the effect of that, even if we decide something on a different ground, as a matter of just, you know, the way the logistics of going of rehearing it as a whole court, we vacate that opinion, don't we? So your point is we haven't overruled the reasoning necessarily, but that opinion kind of goes away.
It does. Again, the court didn't treat it as a normal case. In digging in, again, 12 pages and 20 minutes to dig into this Loper-Bright issue, and you could kind of write a law review article about it. MA, I'm not convinced, is not still good, the original case, the 858 case. But even so, that formulation of unwilling and unable is in the air at the time. In MA, they were citing to Ninth Circuit cases, Lasso Mahano, Bolanos, I think there's another one, that predated Acosta, predated Chevron, obviously, that were saying the same thing. That's where this idea comes from. And it showed by 2004, it's a discrete elemental portion of the 1101-42A refugee definition in Lopez Soto. Lopez Soto, I don't think went en banc. I think it was vacated on joint motion by the parties. But that's not the only case. That's the one building a timeline, that's what I put in there. But there are other unpublished cases. You can see this through line being built. And ultimately, it doesn't matter because this through line goes through from the 1980s until Portillo Flores and beyond. And the point of it is, it's the court's own organic formulation, understanding of persecution as it evolves over the years. It has nothing to do with deference to the agency. The first time matter of Acosta comes up, as you said, is in Crespin Valladares. And in that case, all the court really does is just sort of announce the rule again and point out, it cites to other out-of-circuit cases and the regulations in the footnote and says, it's clear the INA has this element in it.
Can I ask you an unrelated question to that? This is on the ineffective assistance of counsel appeal. And I understand your prejudice argument as it relates to unwilling and unable. But what's your response to the position that counsel provided deficient performance by not making a claim through, is it Coney? Yeah.
The petitioner, I feel like the petitioner at the podium here was being a little too precious about how prior counsel characterized his view of the claim. Mostly, he just didn't feel like there was a cognizable nexus there for Coney. So really, this is a dispute between current and former counsel about how strong her personal nexus claim was. That counsel felt like it was essentially a hat on a hat. We're not going to put her claim in when she already has this claim. He felt it would make it weaker rather than stronger. I mean, that's one view of it, but that doesn't necessarily mean if reasonable attorneys are going to disagree with each other, that it's the wrong call to put all his eggs in one basket. It's not clear to me, if there had been an extra claim for Coney, what else would have happened again, not for nothing, because of the state action element. She can't prove it. That's the prejudice part. But even beyond that.
But we do, I mean, the PSG that was articulated in ineffective assistance counsel is probably something that is consistent with our precedent, right?
Sure.
And so the point would be, that counsel, was concerned enough about nexus that, which was an issue in both cases, that adding an additional claim about nexus might, defeat the claims as a whole?
Just to kind of make it a bit too much, because the threats are all directed to the lead petitioner. Some of them, I mean, the threats do sort of branch out and say, we're going to hurt you and your family. That's where Coney's nexus could come in. Prior counsel felt like that wasn't enough. I'm not judging it. That's what he decided to go with. And it's reasonable enough. I can't say what would have happened if they had put that before the board, but I don't think it's enough to say as a matter of law that it's ineffective not to have put that claim. And I know in the arguments in a footnote, we don't think waiver applies because, waivers waive claims of error. We're not claiming error. This is an issue the petitioner raised. So the claim's in the record and the decision's in the record. And it's a de novo review, so you can rule on the issue without having to just sort of take the petitioner's formulation of that. Do not recall what I was saying about the government role element. I was talking about Loper-Bright, MA, and the cases forward. Right. So Loper-Bright doesn't have anything to say about a line of cases that the court came up with on its own. That's one reason why Loper-Bright has no effect here. The other reason, as you pointed out during the first part of the argument, is stare decisis. Justice Roberts is very clear that stare decisis shields decision made under the guise of Chevron from being instantly undermined. The chaos that would be caused by immediately undermining every Chevron-reliant case was a theme at oral argument. This was in the air. And it's Justice Kagan's understanding in the dissent that the thousands of Chevron-reliant cases are still intact. Her concern was that now they could be undermined with the special justification rationale that the court put forward about attacking stare decisis. Petitioner hasn't brought a special justification. He just says stare decisis isn't a thing anymore. That's not true. Just a month ago, the court issued Gibbons v. Gibbs, this court, where you said that if stare decisis means anything, it means that one panel can overrule the former panel about the actual legal issue that was decided. When courts analyze issues under Chevron, they are not deciding Chevron. They are deciding the legal issue. In this case, it would be the unable or unwilling element. So again, Loper-Bright has nothing to say about that, even if we do somehow find deference in here. It's not licensed to rewrite immigration law. Loper-Bright just doesn't affect anything. And I think we want to kind of keep in mind my understanding of the petitioner's preferred formulation of the unable or unwilling element is not that it doesn't exist, even though it's not in the text, it's that it should be part of the well-founded fear analysis, which would mean that any person who is harmed at a sufficient level with a nexus to a protected ground could establish the presumption of a well-founded fear. If you get past persecution, your fear is presumed. That means even if a person is harmed by someone that the government can and does control, they would still get a presumption that their fear is well-founded, then the government would have the burden of proving that their home country couldn't not protect them from the party that maybe isn't even identified, because it doesn't matter. It could be an anonymous phone call in this circuit. Threats, severe threats, rise to the level. So anonymous phone call says, "I don't like your political opinion, I'm gonna kill you." That person, every person like that, in every country, is presumed to have a good asylum case, and the government would have to disprove it under the petitioner's formulation. That is an egregiously, breathtakingly overbroad change in the law to rest on Loper-Bright's narrow holding. I mean, it's an important case, but the holding is narrow. It just says mandatory deference is no more. It doesn't say you can't defer. It says you don't have to anymore. It actually reaffirms Skidmore, so that's another path the court could take. If it likes, you could just defer to Acosta now. Because the decision is well-reasoned, it's the best reading of the statute. Every other circuit in the United States has adopted this rule in some form or another. They've rested on refugee, they rested on persecution. Wherever it comes from, it's there. It predated 1101A42A. It comes from the United Nations protocols that we adopted in the treaty. It's a settled issue of law is the point. Loper-Bright can't undo that just by saying don't defer anymore. These are completely inapposite concepts. I think I've said everything I want to say, and I'm just about out of time. So if there are no further questions. Right.
Thank you, Mr. Chigar.
Thank you all very much.
Thank you. Well, she get it. Judge Berman, do you have any further questions?
No, thank you.
No.
Thank you, Your Honors. To start with Nexus, Nexus is only relevant to Brian's asylum claim. It is not relevant at all to Coney's asylum claim. So even if the court rejects our Nexus argument, it can still rule in our favor if it agrees with our arguments on unable and unwilling and ineffective assistance. Our only Nexus-related argument was that the board applied the wrong standard of review. So that's the only question before the court, not the actual merits.
Can I ask you the question
Yes.
that I asked your colleague, which is that even if we were to agree with you on the nexus argument and the incorrect standard of review, isn't there an alternative ground for supporting affirmance that on the unwilling and unable to control MS-13? So in other words, we would have to find for you on both. Isn't that right?
Correct. To prevail, we definitely need to win on unable or unwilling. But then if we also simply win on ineffective assistance, then that would be enough to grant the petition for review. Now on competence.
But if we were to find for you on this issue of the improper standard of review, that would not be enough for a remand.
That alone would not be enough. You would also have to rule for us on unable or unwilling. Yes, we need to win on unable or unwilling in order to prevail in this case. We concede that.
Thank you.
If I may address competence. Yes.
I want you to do that, and I want to be real.
Yeah.
I don't want to take up all your time, but I didn't understand why Nexus is not an issue for the alternative PSG under your ineffective claim.
Well, the board didn't reach, and frankly, there's no dispute that Coney is a member of a valid particular social group. And I think also the only possible reason that the gang would have threatened her is because she was married to Brian. She was not a witness.
Understand.
If that answers your question, yes.
Thank you.
Now on competence, the prior attorney's explanation, it was not about Nexus at all. It was simply about the fact that Coney herself had not been the victim of past persecution, in his view. I would point the court to page 39 of the joint appendix. on the first page of his response where he says, irrespective of the ability to demonstrate her membership in a particular social group consisting of the immediate family members of Brian, there was absolutely no evidence that she was persecuted on account of her membership in that group, or indeed that she had been persecuted at all. That's prior counsel's own words. And then again, he says the same thing in his concluding paragraph. It was my strategic judgment at the time that while Brian's petition for asylum and evidence in support thereof was sufficient to establish persecution, there was no evidence of persecution of Coney, meaning that the filing of a separate petition on her behalf would have been meritless and without merit. So I think it's clear that the prior attorney was worried just about the lack of persecution. With regard to unable or unwilling, I would say this. If the police responding to a murder in broad daylight was enough to show ability to control, then no asylum applicant would ever be able to satisfy that requirement. And here also, we are not simply relying on country conditions evidence. We are relying on evidence specific to this case, namely that my client testified credibly that the gang members who threatened him specifically said that they had sources inside the police station who would tell them if he contacted them. So that is evidence specific to this case. And if MS-13 has sources inside the police, I don't see how the police would be able to control MS-13, even if they do send officers to a murder in broad daylight. And that testimony was also corroborated by the report from the Canadian government, which noted that MS-13 had infiltrated the police. And in closing, I would simply note that by statute, Congress has required asylum applicants to submit reasonably available corroborating evidence. And I don't see why Congress would do that if immigration judges were simply free not to engage with it at all. And in many cases, immigration judges will say, even if I don't mention it, I have considered all the evidence in the record. The immigration judge didn't even do that in this case. The court has no further questions.
Ms. Brennan?
Thank you.
You're good. Thank you, counsel. We'll come down and greet you. And we'll go to our next case.
Ms. Manita? Thank you. I know it's difficult because I'm on the screen. You can look wherever you want to look. Thank you. So you've mentioned that our court has yet to render a ruling on this question, but that other circuits have. Have any circuits interpreted the statute the way you're suggesting we should? And you, go ahead.
Confusing, but I'm trying to make sure I understand what this most recent argument is, because it sounds like you're talking about the Sixth Circuit case, which I think as a matter of statutory interpretation rules contrary to the way you say. And I think you're talking about our Johnson case, which, although it involves a different statute, arguably interprets that statute different than your argument here. It sounds like what you're saying is in the application of that statute, which you contend to be wrong, there's been a rigorous application of the mens rea. But that may be true, but that's a separate issue, isn't it?
It is a separate issue, but the implication when, especially in the Sixth Circuit case, the implication of the court saying we can do this in the aggregate, we can count the other persons in the aggregate, but then nevertheless looking at each individual predicate act and determining whether the mens rea was there for these other individuals, it suggests that, in fact, the analysis really does have to be done on an individual basis of each of the predicate acts. And I would
I
suggest.
thought that just sounds to me like your sufficiency argument, that, we got to show that they were acting in concert, or there's got to be evidence of that. And the only way you do it is look at the facts of the incidents. But anyway, I'm not trying to-
Undoubtedly, there is, I mean, there's certainly overlap between my sufficiency argument and this argument, Your Honor. But I think that the key is that the interpretation that these other circuits have applied to the in concert phrasing really dilutes the statutory requirement and the statutory intent. The intent of this statute to go after enterprises, it's meant to target organized and collaborative criminal behavior, coordinated criminal behavior. And if we read it to allow an aggregate, we don't have coordinated criminal behavior. We could, under that reading, have 3 predicate acts, only one of which is committed with other people, and the other 2 committed alone, and it would still somehow satisfy the enterprise. And that really doesn't make any sense. Not only would those acts be punishable under other statutes, some of which also have hefty mandatory minimums, but I mean, just sort of common sense would tell us that that can't be what an enterprise looks like, where you have one defendant committing 3 acts and perhaps only one of them with 3 other persons. There's simply no way. And it simply makes more sense that there be some, at least, commonality to create really a business organization, as it were, that is dealing in the exploitation of children. I think.
Does the statute use any of the words that you're talking about? You said enterprise, business. I mean, as I read it, there's no coordination requirement in the statute.
Well, I respectfully disagree. I respectfully read it as requiring a coordinated effort, because that's what an enterprise is. That's what a criminal enterprise is. That is the difference between an individual criminal act or even a tacit or conspiracy. An enterprise is something more, or else it's a meaningless term. And we know from all our precedents that that's certainly not the case. There are specific statutes that go after enterprises, which the key difference is that we have a coordinated effort to commit a number of enumerated offenses. That's what we find in racketeering, and I suggest that's what is intended here. It's not simply meant to go after 3 distinct conspiracies that have one common actor. And the reading that the 6th and the 3rd and all of the sister circuits, frankly, suggest and have found, that's what it can lead to. And that type of overbroad application is what happened here to Mr. Keener. His activity was largely individual activity, and not even getting to the sufficiency argument, it's necessary really to aggregate in order to find him guilty. But I think that it's somewhat telling that the trial court asked if conspiracy is a lesser included offense of this statute. One of the courts, I believe it was the 8th Circuit, but there was a district court that did find that it was. Frankly, the government and I agreed that it's not. Specifically because this is a different crime. But it is somewhat telling that the trial court, who tried this at a bench trial, asked that question because what really was proved at most were individual distinct conspiracies, all involving Necris, the user Necris, which for the sake of argument we'll call the appellant here. And so I think that's the danger of this interpretation of the statute, that someone who may be guilty of conspiracies, but not guilty of running or being a part of a criminal enterprise, is still going to be sucked into this, as Mr. Keener has been, and I would argue some of the defendants in those other circuits were. Now, unless the court has any further questions on that, I wanted to address the Brady issue. The district court did deny our motion to vacate, which of course this court would normally review as an abuse of discretion. But in finding that there was a Brady violation, the district court also found that it wasn't material, that there, and our argument is applying the wrong standard to that question, found that although there was a violation, it was not material. My argument is that when you make that determination, you're saying there wasn't a Brady violation. Materiality is an element of a Brady violation. And so I'm asking this court to review that determination, including the materiality de novo, as part and parcel of the finding on Brady. And note that the district court applied the wrong question in determining materiality, and instead of whether the district court would have ruled differently, whether there would be a reasonable probability if disclosed and used effectively, the result would have been different. The district court looked, at the bench trial in hindsight and really only asked, would I have ruled differently? But the defense's entire approach to the case may have been different had this, the results of this administrative subpoena been timely disclosed, including whether or not we would have opted for a bench trial or a jury trial. Because quite frankly, this issue that is illustrated by the return of this Google subpoena was the focus of the defense. And instead of it being a sort of, and I'll use the district court's word, implausible theory of impersonation, this is solid evidence of interference with the Negris account that, in our estimation, undermines the confidence of the outcome and is troubling enough to constitute an extreme case. I don't know what happened, but it is an unbelievable coincidence that the one thing that was missing and was not disclosed until it was asked for after trial is something that speaks directly to the issue of third-party interference with that user account. And so I understand the government's argument that if the court agrees there was a violation, that normally there'd be a remand, but I would submit that this is an extreme enough situation where there should be a dismissal with prejudice. This wasn't simply a late disclosure. It would not have been given to us at all had I not asked after trial. And now, both of these arguments really do overlap with my sufficiency argument. We're talking about, at the end of the day, the actions of an individual sitting behind, sitting in front of his computer and chatting. Even in the comments, the running group chat, this is not constituting an enterprise. It's akin to sort of standing in a room and saying something out loud and not really knowing or caring whether anybody else hears you, except that one individual with whom you cannot conspire, with whom you cannot be in an enterprise, and that would be the young victim who ultimately produces the image. And so, notwithstanding the impersonation argument, the proof of a true enterprise when you have this sort of individualized activity we submit simply wasn't there. And turning to the impersonation defense, the focus.
Counsel, is your light not working?
I'm sorry?
Your light's not working?
Oh, I'm sorry. I didn't realize did I go over?
Yeah,
I'm sorry, I didn't realize I had gone over.
4 minutes and you didn't ask for permission to go.
I apologize.
No, but you were going slowly as if you had more time. That's why I stopped you. But go ahead and finish it. But I want to ask just one quick question. I think you did. I want to make sure. Are you conceding, you said, as to the victim, more than one victim, you think that that's accomplished? It doesn't have to be more than one for each incident? Is that you said? You can.
I think that's a reasonable interpretation, yes, that the
what?
victim count, the victim count is part of the clause that of a series, so the victim count applies to the series.
So
yes.
it's simple. So you're saying that it could be the same one person the same time, each time, same one person.
I'm saying that there could be only 2 victims of the entire series of offenses.
Right, okay.
Right.
So it could be one time, one second time, but then it would have to be 2 the third time?
No, it could be, well, it has to be more than 2 victims. So there could be 1 victim of each of 3 predicate offenses.
That's what I'm saying, so.
Right. But my
I'm trying to
argument,
understand your position. I don't want you to re-argue it. Just tell me whether or not, do you concede that it could be just one person each time?
yes,
Okay, okay.
thank you.
May it please the court, counsel for the appellant, good morning, your honors. Seth Schlesinger on behalf of the United States. And if there are no initial questions, I thought that I'd begin by addressing the point that was principally addressed in my opposing counsel's argument, which was the interpretation of subsection G2's requirement that a person commit those certain enumerated felony violations in concert with 3 or more other persons, and specifically whether the 3 or more other persons can be tallied across the entire series or have to be involved with each individual predicate felony violation. And this court has been very, very clear when it comes to statutory interpretation, that interpretation begins with the text of the statute, and that when the text of the statute is clear, that clear text controls the interpretation. And here the statute is crystal clear, because Section G2 says that the offenses, a person who commits those offenses in concert with 3 or more other persons and meets the other elements of the statute, has committed the offense defined by the statute. If Congress had wanted to draft a statute that created or defined child exploitation enterprises as only those in which at least 4 different individuals were involved in each individual underlying act of child exploitation, Congress could easily have done so. They could have simply drafted a statute that read and commits each offense in concert with 3 or more other persons. But Congress did not do that. Their statute.
That's fair, and that supports your argument. They also, could have said the series of offenses rather than those offenses. Your colleague has an alternative way it could have been more clear. What's your response to that?
Well, you're certainly right, Your Honor. There's no, the grammatical reality is there's no limit to the different formulations that could linguistically have created. I would suggest in direct response to Your Honor's question that those offenses is equivalent to the series of felony violations. It's perfectly natural grammatically when talking about a series of items to then refer to those items, meaning the series of items. It's the collection, in this case, the sort of plural collection of items being a series of items. And so I think in context, those offenses means.
Well, first of all, those offenses refers to what?
The series of predicate.
No. What are the offenses?
The
right?
offense.
Right. It's a chart, one, right? One of the enumerated ones, right?
Exactly right.
110, 117, right?
Correct, Your Honor, yes.
Right. So it's those offenses in concert with. That would mean all of those offenses, or whichever one it is, would have to be in concert with 3 or more persons. That's a fair and clear reading of the statute.
It is, Your Honor, all of them together, the series of felony
It doesn't
violations.
say that. It says those offenses, those ones that are previously mentioned, which you say it is, those offenses are done so in concert with 3 or more persons. So each is implicit in that because it says those offenses.
I respectfully disagree, Your Honor. I think when
You disagree, but why is that not a fair reading of it?
because those offenses is a referent to the immediately preceding clause in the statute, which is the series of felony
No, it's
violations.
not. Those offenses directly relate to the ones that are enumerated. Those offenses are the ones listed. That's what gets you in. It has to be committing those offenses, and it's very clear. Congress laid out which ones they're talking about, and we know here which ones they are. It doesn't relate to anything but that. Those offenses in concert with 3 or more persons.
Your Honor is certainly correct. Those offenses must be, to qualify, they have to be
And they have to be committed in concert with 3 or more persons.
correct, Your Honor.
Well, that's right. But then each time you violate it, it has to be in concert with 3 or more persons. Why is that not a clear and fair reading of the statute?
I think the most straightforward reason it's not, Your Honor, is that those offenses, which is a reference to another portion of the statute, is a reference to
A portion of the statute? No, it's a reference to the statutes that are enumerated. They are enumerated. Wait a minute, Count, let's get something. Do you agree that statutes are enumerated here?
Yes.
Do you agree that those offenses are the statutes that are enumerated here?
Yes.
And do you agree that it says in concert, they're done in concert with 3 or more persons?
I do see that, Your Honor, yes.
Well, then how is that not a fair, straightforward reading of the statute? That's what I want you to get to. I'm not trying, it sounds like I'm arguing with you, but I'm not, but I'm just trying to answer my question. How do you say that's not a fair reading? Now, I know you're saying you don't want it to be read that way. I appreciate that. You're a good counsel and you represent your client. But text has to, people who are textualists, they always talk about, what Congress meant. It was what they said, right? It said it. It said it has to be, those offenses have to be done with 3 or more persons.
Yeah, I'm very sorry to respectfully differ with you, Your Honor.
You've done, okay. Well, I'll leave you alone because you really have no real legal retort to what I'm saying. You just say you disagree.
I think the most important legal retort is that the word each does not appear.
So it doesn't have to. I mean, everybody has word choices. I mean, it's called word economy. Lawyers write that way, active voice, word economy, strong verbs, and all that kind of thing. You don't have to put all that extraneous thing because you look and see what's enumerated, and those are the offenses they're talking about, and how should they be done? In concert with 3 or more persons. Bing.
Again, Your Honor.
But you can move on, though, if that's all you have to say about it.
Well, in addition, Your Honor, to the points that I've attempted to make about the straightforward, what we believe is the straightforward and clear text of the statute, if the court were to hold differently or to hold in accord with the appellant's position in this, it would be in very substantial tension with this court's own decision in the Johnson case, interpreting the continuing criminal enterprise statute, which is not exactly the same, but it's very, very similar, and the statute structurally is quite similar, even though it focuses on narcotics trafficking organizations as opposed to child exploitation organizations. And critically, it also has an in concert with requirement. And with respect to Section 848, the CCE statute, this court held in Johnson, actually citing an even earlier case decided by this court, that the government need not prove that the 5 individuals, which is the requirement for 848, that the government need not prove that the 5 individuals were supervised and acted in concert at the same time, or even that they were collectively engaged in at least one specific offense. So the court was quite clear with respect to Section 848 in Johnson, which, while it has some different components with respect to the in concert with requirement, is virtually identically situated with Section 2252 AAG, that there's no requirement.
And they're having established that there's a relationship among those people. Each person doesn't have to be present. That's a different case, isn't it? That's a different statutory interpretation. These people who have established to be, in terms of Johnson, or involved, no, each person doesn't have to be involved every time they violate it. That's different here. It's not talking about that. It's saying committing those offenses. I mean, it's different. I mean, apples and oranges, we have to look at different statutes, different ways.
Well, they are different statutes, but I think in the critical respects, they are very similar to the point of being almost identical. Section 848 refers to a continuing series of violations which are undertaken by such person in concert with, whereas child exploitation enterprise statute refers to a series of felony violations and commits those offenses in concert with. So there are slight variations in the language.
Which are undertaken, right?
Right.
Which are undertaken, which means that in terms of actual involvement, they're undertaken in concert with the drug trafficking. It's a drug trafficking case, right, statute, isn't it?
It is, it is. And I don't think that.
This is not. It's different.
This is not drug trafficking.
I understand. That's your best argument, that we can clear up this by that statute alone. That's right. That's your position. I mean, if it is, it's fine.
All right, is that our best argument?
No, I'm not saying your best. Is that an argument at all?
It certainly is.
Okay.
It is, Your Honor, yes. So I think our argument is, the first part of the argument is, I think, the clear text of the statute. The second is, this court has a controlling precedent directly on point with respect to a statute that, in the critical respect, is fundamentally identical in the critical respect to the statute that's being considered here today. And the third point that the government would allude to is something that came up a bit in my colleague's section of the argument, which is the decisions of the other courts of appeals that have confronted this very issue. And the other courts of appeals, there's 3 of them that have considered it. They're unanimous that the number of other persons with whom the person acts in concert can be tallied across the entire series of felony violations. The Third Circuit, the Sixth Circuit, and the Ninth Circuits all agree. As my colleague acknowledged in response to Judge Berner, there are no courts of appeals that come out the other way on this.
None of which are controlling to this court.
None of which are controlling. That's certainly correct, Your Honor. These are all decisions of other courts of appeals, and so a decision to the contrary by this court, of course, would create a circuit split, and I don't think there's any basis for doing that, particularly in view of the other considerations I've outlined related to the clarity of the text and this court's precedent on Section 848. I would also invite the court to just consider how cramped of reading it would be.
But it should be a cramped of reading. You know why? Because it's a statute that requires a 20-year mandatory sentence. And it used to be something called the rule of lenity that used to exist, but I still remember, and I think it has, that statutes in criminal, especially one with a mandatory, should have these ambiguities, if there are any questions, and to inure to the benefit of the accused. Is that right? Is that what the doctrine of right, lenity, right?
That is the rule of lenity.
And so you were talking about this is a cramped reading. A cramped reading, that's what our founders wanted, a cramped reading in a sense, because to take away life and liberty is an important aspect of it. That's why all the rights and Sixth Amendment rights, for example, don't you think it's interesting that there's no rights in the Bill of Rights for the government? They're all to the defendant. It's not, of course, but you know why? Because they knew the government would take their rights. You don't need anybody to say you have a right to bring witnesses and to subpoena people and all those things, because they know the government would grab it. So the founders were smart. They said, no, we need to protect the people. And in the sense that you're saying, well, we're cramped here. It's supposed to be cramped. It's supposed to be difficult to put a person in prison for a mandatory 20 years, no matter what the substance of the crime, alleged crime is. So when you talk about it's a cramp, I mean, it is cramped. It's cramped constitutionally so by the founders. People who want to be originalists, they're originalists when it helps, but not originalists in a sense, when in terms of protecting the people who the Constitution intended to protect in the Bill of Rights. But go ahead and continue your argument. But I just had to respond to that when you said it's cramping. Go ahead.
I certainly have no quibble with any points you raised, Judge Gregory, and perhaps I shouldn't have used that word.
Well, go ahead.
I think it would be inconsistent with Congress's manifest purpose in enacting this child exploitation enterprise statute to insist that no organization will qualify as a child exploitation enterprise no matter how many victims are involved, no matter how many perpetrators are involved, no matter how closely they act in concert, no matter how heinous the conduct is, unless there are at least 4 of them collectively engaged in the same time.
We can't, I mean, your colleague talked about purpose. Now you're talking about purpose. I mean, The best way we understand purpose, isn't it, is based on what is written in the statute. But I mean, you're welcome to make whatever arguments you get, but I have a hard time figuring out what purposes are behind things besides what's written down.
You're quite right, Your Honor, and there's a reason I led with the clear text of the statute and saved this for my last. So I'll leave it with that, and I'll certainly, if there are no other questions on this issue from the court, I'll certainly leave the court with that on the issue of the in concert with requirement. With respect to the Brady claim that was briefly raised by the opposing counsel, as the court is, of course, well aware, to prevail on a Brady claim, the defendant must prove that evidence was favorable to him, either because it was exculpatory or impeaching, in this case, the claim exculpatory, and also material to the defense. In other words, prejudice must have ensued from, in this case, what both sides have acknowledged was an inadvertent failure to disclose two subpoena returns. And this court's held that exculpatory in this context means that the evidence, quote, may make the difference between conviction and acquittal, had it been, quote, disclosed and used effectively, and material means, this court has said, quote, likely to have changed the verdict. And in this case—
It should have been produced, correct?
There's no question, and the government acknowledged that in district court. The government, in fact, the government, as soon as it was alerted to the oversight, promptly disclosed it to defense counsel, acknowledged as much in the district court, and certainly happy to reiterate that acknowledgement here in this court. It was inadvertent oversight. It should not have happened. It should have been produced. But it's known beyond any doubt in this case that the failure to turn it over prior to the trial did not affect the verdict. And we know that because this was a bench trial. The trier of fact was the court, and all of this information was presented to the court. The court held a full hearing on all of this, and the court—
Counsel said that perhaps this would influence their decision whether or not they want a bench trial or a jury trial. Why do you respond to that?
I don't think appellants made that claim. Certainly not in any before the district court, not in any brief before this court. There's never been any suggestion. Even if appellant had made that suggestion, I don't think that plays any part in the prejudice analysis whatsoever.
It would play a part. It just, they'd still, something could affect, a defendant's counsel's strategic decisions. It doesn't necessarily perhaps, meet the materiality or prejudice standard, but, it's not, seems to me, I get your argument's not made, but were it made, I'm not saying this, it could be relevant to that, couldn't it? I mean, again, they still have to make the rest of the prejudice requirement, but
Absolutely.
but to say it doesn't play a role might be a bit much.
Well, I think it would be entirely, again, even had this claim been made at any time in any court, which it has not been, I don't think that, I think it's speculative to sort of imagine that, a jury as opposed to a court would come out, would be more receptive or less to a certain type of defense based on, one or two additional pieces of evidence, and certainly too speculative, I think, to factor into a prejudice analysis where the court has to consider, what would have happened had the material been disclosed. In this case, with this bench trial, we know with certainty what would have happened because the district court considered the information and rendered a finding on the record. The district court said, quote, "I am satisfied that this evidence is not material. It would not, in my view, have made a difference," at 521 of the joint appendix. So again, it's not like maybe a slightly more common version of the situation where it's a jury trial and the court's got to examine the evidence and then sort of, in examining the evidence, draw some conclusions about whether it could have affected a jury's verdict or not. Here we know with empirical certainty that it would not have made a difference because the district court considered it and told us that it would not have made a difference. In effect, the district court's considering it was sort of tantamount to kind of a continuation of the trial because it had been a bench trial beforehand and it was the court that heard the evidence afterwards and reaffirmed its verdict. Now, to be sure, even if we were in that position, similar to if it had been a jury trial and the court had to examine the evidence itself that was the subject of this claim, even then the appellant would surely fall well short of being able to establish that it was prejudicial, and that's for a variety of reasons. I think most directly being the fact that the Google subscriber return at issue, the MC3996250 email account, was only created on October 6th, 2020, and that is subsequent to Mr. Keener's commission of not quite all, but almost all of the predicate acts that are underlying his conviction for engaging in a child exploitation enterprise.
Counsel, you only have a minute left, and I want to get to something related to sufficiency. So do you mind if I, redirect you a little bit? I understand your arguments on sufficiency, and it's not really so much about those as it is what in concert means in this context. Imagine a user of this website who just gets on it and doesn't comment, but is a regular user to everything that's been talked about here. Would that person be acting in concert?
Well, I'll acknowledge first, I think that would be a much closer case than the one we have here. If the person did not comment and also did not undertake or commit any of these enumerated underlying offenses, then
That's what I'm asking, is being on the website and is that making one in concert?
recognizing that's a very different case, I would say no. I don't think just registering an account on the website without more, in part
I'm
not.
saying registered, I'm saying actively using and participating, but not commenting with others.
And I see I'm over my time, Your Honor, if I might respond.
Yes, you may.
If the person is actively participating, including by committing the enumerated felony violations as a part of the website, I do think, and is committed at least the three, and the other elements are met, notwithstanding the lack of commenting, I do think that person could potentially have liability under the statute. Although, factually speaking, if there are no comments of the type that Mr. Keener made, admittedly, it would be more difficult, I think, to prove that that person acted in concert with others as opposed to on their own, notwithstanding that it's on the website. I think it would be a factually more difficult case for the government to prove, because whatever in concert with, means the government would have to prove presumably something about this person's intent or state of mind, and without the words of that person explicating that, it would be more challenging to prove that, even though I do think legally that would be possible. Here, we've got, the record is replete with evidence, and so I don't think it's an issue raised in this case. Thank you. If there are no further questions from the members of the panel.
I just have one follow-up question to Judge Quattlebaum. So I just want to clarify your interpretation. What you're saying is, of the three offenses, two could be committed alone, and the third with three people, and that would satisfy the requirement of in concert with. Is that your interpretation?
Not quite, Your Honor, because all three offenses together have to be committed in concert with. So, in other words, I think if a person commits one predicate act on, let's say, a website like this one with three or more other persons, but then separately on a different website or a different internet service, let's say, receives child pornography on two other occasions, I don't think that is going to meet the definitions of this statute. That's not going to qualify, because the three offenses were not done in concert, notwithstanding that the one had three or more. You have these other two out there that have no connection. They were not done in concert with other persons. Whereas...
So the in concert with language doesn't just modify the number of persons that have to be involved. The predicate acts have to be in concert with one another?
Right, yes, Your Honor. The entire series considered collectively of felony violations has to be committed in concert with three or more other persons. So I don't think it's a simple matter of just having like three columns and then tallying how many persons are involved and how you count those up. It's collectively the entire series of felony violations taken together. And if there's only
So then
one...
why couldn't it be that there were two alone and a third with three people, and together that's three?
Yes, yes, Your Honor.
I hear that's what you're saying, is two could be completely alone and a third with three, and that would satisfy the in concert with requirement.
The offense can be committed by one person, but the offense still has to be committed in concert with.
Each offense.
Each offense must be in concert with, but altogether, it's the series of felony violations that requires the three or more other persons.
All right.
Thank you, Your Honor. I'll simply ask the court to affirm the appellant's conviction.
Thank you, Ms. Schlesinger. Ms. Manita, we're going to give you some time. No, the Fourth Circuit, we don't do that.
I'm sorry,
We're going
I'm
to give you your reserved
It was
5
red.
minutes.
I don't know. It's just been a long time since
Yeah.
I've been here.
I knew it was red. My questions were rhetorical. But go ahead.
So we talked a little bit about, and my colleague talked about it too, about, Congress's intent. And I agree that the best way and the primary way that we determine that is to read the statute. And I'm not necessarily arguing it's unclear. I think it's clear. I think my interpretation is the right one. But even if it were unclear, and I do argue in my brief that if it is unclear, then the rule of lenity should apply. But I do think it's important that we look at the intent, because we do have a congressional record that we can look at. And within that record, it says that, again, we're creating a new crime outlawing child exploitation enterprises, imprisoning for a mandatory minimum sentence of 20 years those who act in concert to commit at least 3 separate violations. And so the requirement of proving an agreement with 3 or more other persons for each predicate act aligns not only with the mens rea standard for conspiracy charges, but it necessitates the higher burden of proof that this statute is supposed to require. It ensures that only those who actively participate in a coordinated effort to commit multiple felonies are held accountable under this enterprise statute. And 848, I would argue, is different. The language is different, and the type of enterprise it goes after is different. But I don't think we need to split the hairs that the government would like us to split. And unless there are any additional questions, that's all that I have.
Thank you, Ms. Manetta.
Thank you to the panel.
Before you leave the podium, I note that you are court appointed.
I am.
And on behalf of the Fourth Circuit, I want to thank you for taking these cases. It's very important to our court, and we appreciate it very much.
I love to do it, so I thank you, Your Honor.
Ms. Schlesinger, we note your able representation of the United States. We'll come down, Greek Council, and proceed to our final case for the term. Ms. Coleman?
Good morning, Judge Gregory. Judge Berner. Thank you. My name's Lex Coleman. I'm appearing for Stephen Simmons. On January 3rd of 2023, there was a search warrant executed at his apartment. They found 2 what they call Glock switches, which literally, looking at my fingertips, is 1.5 by 1 inch, goes under the slide of a pistol, and will allow a Glock pistol with one finger pull to fire more than 1 bullet. They also found 2 auto sears, which are similar devices designed for AR rifles that will allow them to fire more bullets with 1 finger pull. This fit the definition of a machine gun of the National Firearms Act. which requires such devices to be registered and to pay a fee. My client had not done that, and the National Firearms Act further prohibits the possession of such devices if you haven't registered them. Simmons was charged with one count of doing this a few months later, and that's what he pled guilty to. And under 2K2.1, there's a provision he would have started at a base offense level 18 for committing that offense. Now, during the PSR process, a question came up whether it was appropriate to increase his guidelines, referring to 922G for being a prohibited person. And that's because when they executed the search warrant, he had 11 grams of marijuana, and during his statement to authorities incident to that January 2023 arrest, he admitted over the previous 3 months, after catching his wife in an affair, he had resumed using Adderall, and when he couldn't get it, he had used methamphetamine. There was nothing in the record that he was intoxicated at the time he possessed both NFA and non-NFA guns in his apartment. He did not admit to a level of use or type or use of drugs that indicated that he was either fully addicted or so impaired that he posed a consistent danger with it. And again, at the time of his arrest, he was sober. He was on his way leaving the apartment when they executed the warrant in the pre-dawn hours that day. So I objected to that. The government had asked for it. The probation office included it. The ultimate result was an offense level that was substantially higher because he was considered a prohibited person. The non-NFA violative weapons were included in the number of guns attributed to the incident. So
is that in B1?
Yes. No. I'm sorry. Yes, that's B1. That's the B1A and C, excuse me, B and C. The A kicked it from an 18.
Cordova has a question.
Yes, sir.
No, thank you. I wanted to ask about B1, which is one of the, I think related to what you're saying, is that
Yes.
all the guns, whether they're NFA, were considered in totaling up those number of guns.
Correct.
I'm trying to make sure I'm understanding B1 right. It says, the offense involved 3 or more firearms. And the offense in B1, isn't it referring to the offense of conviction?
That's a good question, Your Honor. I've always kind of done it broadly where the guidelines define offense as including the relevant conduct.
Certainly, to me, relevant conduct is part of sentencing at times, but
Right.
just reading the offense, it seems to me that would apply to the offense at issue here, which is.
That's certainly how I've been arguing it, yes.
Yeah, the offense only involved at most 3 guns or weapons, right?
There were, I think, between 8 and 24 NFA weapons, which would, in my mind, there were silencers and other things besides the auto sears and the
But it
Glock
would-
switch.
But if it was less than 25
Correct.
NFA arguments, NFA weapons, and the offense applies to failure to register NFA weapons, it would be an incorrect application of the guidelines.
Correct.
Without even thinking about Bruin or Second Amendment.
Right, but correct.
Because your argument is that if you consider constitutionally protected weapons, it violates Bruin. But if B1 only applies to the NFA weapons, you're not challenging that NFA weapons and the restrictions on that violate Bruin.
That's correct. We chose not to in that case. I've got another one coming up where I have, but
Yeah.
I made the decision in that case to leave it alone. And that's how we thought we were doing going into the sentencing until the prohibited person came up.
But so if what we just talked about's right, at least for the 0.6, you add 6 points, we address that without doing a Bruin analysis at
You
step
could.
1 or step 2.
It could be 4 instead of 6, and that would have been incorrectly calculated. You're right.
And the district court should go back and apply B1 correctly.
At a minimum there, yes. But A comes into this as well because we get the 2 additional offense levels out of that.
But do you mind if I ask you about that?
Not at all.
While we're there? You seem to argue that, as I understand the A4 analysis, you're not challenging anything about the part of A4 that involves the NFA violation.
Correct.
And your reference, your complaint about A4 is the incorporation, to the extent it's incorporated, of 922G3.
Correct.
Is it fair to say, I mean, the statute says is a prohibited person at the time of the offense, and then the commentary says prohibited person includes someone who's described in 922G3?
Correct.
So why isn't that just saying we bring from 922G3 the definition or description of users and incorporate that definition, but we're not really doing a 922G3 conviction?
Well, you can't have one, well, it's not a conviction, you're right, but you're still looking at the elements of the offense. I mean, we have that from Rehafe. This is not a regulatory statute with a minimum penalty. This is something that if it was under G3, now with the Bipartisan Reform Act would be 15 years in prison as a maximum.
But if we had, if there was a statute that said you can't, this is maybe silly, but you can't, own a souped-up Corvette if you're a prohibited person under 922G3.
Well, you
That
don't have a
wouldn't be
constitutional
obviously-
right to have a souped-up Corvette. You do have a constitutional right to have a gun, and that's the problem.
But you
is
don't
that-
have a constitutional right to have an NFA. The Second Amendment doesn't protect the NFA weapons, does it?
Right now, for a different reason, we saw that in Bianchi and we saw it in Price.
But
is
that's my
that-
point. If the weapon, based on Bianchi, is not protected, and why does utilization of 922G3's prohibited person implicate Bruin?
You're not going to punish somebody for their race. You're not going to punish somebody for their religion. You're not going to punish someone for the other First Amendment protected conduct of their political orientation or who they associate with necessarily. You might with felons, but that's different. That would be an exception. So this is Second Amendment protected conduct right now, applying Bruin, applying even Rahimi, and that is being used to increase the penalty here. It's
How's
not.
it Second Amendment? I'm sorry to interrupt you. Sure. I'm really interested in your response. But how is it Second Amendment conduct if the weapon is, based on our recent precedent, not protected conduct, and the reference to 922G3 is not a 922G3 conviction, but the definition of a user?
That's getting into this was before the variant stage, the 3553A phase. And that's very broad, right? You can look at the history and characteristics of the offender in fashioning an appropriate sentence, which, as Beckles said, within the statutory range. What the guidelines are doing is grabbing out to the Gun Control Act and saying, hey, we're going to enhance punishment based on your status. Rehab says that's so important, we even have to have a knowing element added to it. So just saying it glosses the definition, that's okay, you're still getting an unconstitutional definition of conduct, which
But why wouldn't that apply to my Corvette example then?
Because again, you don't have a constitutional right to have the Corvette.
Yeah, but you don't have a constitutional right to have an NFA weapon.
Right, but I have a non-NFA weapon. You're right with the NFA.
But there's no enhancement based on your non-NFA weapon in A4.
That goes back to the status that it was worse.
The status
And
from...
I'm sorry, don't
No,
confuse
go
what
ahead.
I'm saying. I'm not saying that it's okay, you can't be a drug user and we can enhance the NFA punishment. Not saying that. I'm saying the status of being a G3 defined to the extent it clearly defines anything still violates Bruin, and you can't use that to enhance his punishment here in determining his guidelines. So even if you lifted it on the Corvette, say we had a constitutional right to have a Corvette, that would still be inappropriate, as it was in, the NFA was fine, because it didn't object to it. In later thinking and analysis, I don't think it applies, but I didn't argue it in this case. But there are two components of it. There's a type of weapon, and there's the status. And we have had since Heller, we saw this with the core, non-core before Bruin, all these reasons to come up with a diminished Second Amendment status to maintain the status quo. That was not in the text of the Second Amendment and really wasn't in Bruin. And the United States has argued in countless cases, and I hope, even if I lose this appeal, you put this to bed, just like Rahimi did with responsible. That Heller did not ruin. The Supreme Court has not ruled that Second Amendment only applies to perfect people and law-abiding citizens. If you turn around and say that, well, the way this is structured, you don't win, please make that finding. Please clear that point. So in future cases, we are focusing on the historical application, if it's applicable, if we're really doing a Bruin challenge, instead of this. Most of the briefing in this case is, my client's not entitled to Second Amendment protection. That's not what Heller says. Heller says you're part of the people, even if you have polka dots, COVID, and you can't say anything but cuss words. And then you get down, we've got another overlay of the type of gun. We have all these layers to keep from shifting the burden to the government, which was the whole point of Bruin, the deference to a fundamental right. And as you said in one of the previous arguments about 20 years imprisonment, it's supposed to be harder to regulate this conduct. It's not a prohibition on it, but it's a burden to carry, Judge Gregory. And all of this totaled up on the front end of Bruin Step 1 is doing what? It's doing what we were doing with means and scrutiny. It's putting all the burden back on the defendant, on the citizen being regulated, on the citizen being denied the right. I mean, this came up, this is weird how this came up in a sentencing context. It was an opportunity. We've got Alston coming up, and I'm sorry I missed it before, that has this directly in a case where in North Carolina, they said 922G3 is applied to him, is unconstitutional. This is in a sentencing context, but without 922G3 being unconstitutional, other than the B1 relief we would get, the main relief would be with A, because in addition to the type of gun, the status, if it's unconstitutional, I would have had a 30 to 37 month guideline range to work with. And instead, I started off with 57 to 71 months. He came down 2 years.
Mr. Coleman?
Yes, ma'am.
So
Sorry, Judge Brennan.
can we get to your Bruin Step 2 challenge? I understand you're making, you to be making an as-applied challenge
Yes,
to 922G3, is that right? You're
Yes.
not making a facial challenge.
yes,
So, and your client admitted to using methamphetamine, is that right?
right.
And I understand there's also evidence of prior domestic violence, is that right?
That was
But the court-
disputed, and Judge Chambers did not consider that at sentencing. That was in the PSR, but we contested that, and that wasn't addressed at his sentencing.
So just focusing on the methamphetamine use, is it your argument then that a finding that an individual who admitted to using methamphetamine is not then properly, does not come properly under 922G3 as
Yes.
applied to this individual?
Yes, without more, because, and that's what I addressed on the historical side. Conley picked up on this in the Fifth Circuit.
Right, but Connolly was a non-violent marijuana smoker. It was not somebody who was admitted to using methamphetamine.
Or Adderall to stabilize himself during the day. I've had countless clients with ADHD who are a Tasmanian devil until they get the stimulant to settle down. And they use methamphetamine prophylactically like that, not to go on the binges or to pull. There's no evidence in the record of his behavior of either consuming an amount of methamphetamine for a period of time, purity, or engaging in regular behavior that would have justified his disarmament just because and in a period of emotional stress, he used it to replace Adderall when he couldn't get a prescription. So just saying we've got one drug.
So in looking at the historical analogs that the government has pointed out, are
Yes.
you suggesting that under those historical analogs, there would have had to have been evidence of dangerous behavior or evidence of individuals acting in a manner that was dangerous?
I briefed way away from the word dangerousness because it is so open-ended. Certainly, you would need more of that and evidence of that, but those analogs, they address acute events, whether you're going to how the mentally ill were treated, that were disarmed during the period of lunacy, which was considered temporary. They didn't forfeit their rights. They may have been locked up and some of their property sold to pay for their period of confinement. But when the malady passed, they were released and free to do what they wanted with their property. And even if one of their guns had been sold, they could go get another one. It wasn't a permanent disarmament like G4 or G3. The same with the intoxication laws, just like our Frey laws analyzed in Rahimi. Those had to do with temporary periods of things. And again, here, other than what the wife said in the PSR, which was not substantiated by anything, and the client adamantly disputed its sentencing, and the government put on no evidence to contradict, there was no evidence of inherent dangerousness of behavior on his part that would have justified disarming him. And there's the way G3 is written, Connolly analyzed this very, very well. Any historical analog that could potentially apply under that really, really broad statute, which we've arguably acknowledged is mushy on its standard.
That's a facial
apply-
challenge, and you're not making a facial challenge. You're making an as applied challenge. Isn't that right?
That's correct. Also, the other case is I'm more making as applied here, but there's still a category, a subcategory within that of substance users that are not dangerously impaired and are sober. It makes sense to disarm someone temporarily when the guy's going to run out and in public carry and shoot up a bar, a house, a church. Sure, take it away till they sober up. Let them pay their fine.
Your client admitted that he was not sober. He admitted that he was a user of methamphetamine.
He didn't say he was intoxicated.
G3, no, but he admitted that he was a user of
Yes.
methamphetamine, and 922 G3 would no longer apply to him when he stopped using. So it's not a permanent prohibition on your client. It's a prohibition during a time when he admitted to being a user of methamphetamine.
That's not completely correct, Your Honor, because under the ATF's regulation, it can be over a year. And we don't know where that line falls, where a citizen would be disarmed without a court finding or ruling of dangerousness or any behavior that supports that based on just, I took some meth, or I hit a bowl, or I smoked a joint during the Super Bowl. Gosh, by Christmas, can I have my gun again because people might rip off my packages or go after my kids? We don't know. And that's the problem with it as applied. It's a whole category of people who are still sober. And that goes back looking at the historical, I didn't mean to point at you, Troy, so much as the historical analogs. When people were sober historically, they did not disarm them. There were no justices of the peace locking people up. There were no people denied malicious service. They could have been habitual alcoholics and drunks. In fact, historically, with the sugarcane production by Britain and the Virgin Islands, we had more rum in the United States than the rest of the world for half a century. We were not just loud and proud patriots, we drank a lot. And yet they weren't disarmed until it got to the point of carrying her publicly. Their conduct with a gun, their active employment of a gun, is what they temporarily and acutely address by disarmament. They never pull from them and said permanently you can never have a gun again. So the how and why of G3 on this, at least as applied to my client, is not an acceptable historical analog even under the much more deferential standard Rahimi applied. And I'm not so sure Rahimi got rid of the distinctly similar analysis even with the comment about a law in amber. The Fifth Circuit below only applied the relevantly similar analysis. They didn't even try and analyze it under the distinctly similar standard. And that gets more and more that has bothered me as defense counsel. I'm running over time, but I want to make this one point. We have all this evidence that people were not traditionally disarmed at the time of the founding. They certainly were not permanently disarmed. And yet, whether it's relevantly similar or not, whether it has to match or not, that is so readily dismissed as inapplicable now. I mean, even Justice Barrett in her concurrence with Rahimi was talking about, well, the policy choices today are different, but we've got Heller saying, this is a policy decision you can't change now because it happened at the time of the founding. And yet they look at the result and look at Rahimi. It grabbed surety laws and grabbed affray laws, which was actually going out and doing something in public dangerous with a gun, put together an analog sandwich and said, at least for this temporary thing during this protective order, that's okay. It didn't go any further than that. G3 does. G3 is permanent. And I remember arguing Carter before Judge Niemeyer and Judge Hamilton and coming down and saying, well, they can control it, they can stop it. No, the law has evolved from that, and it's not only a broad prohibition and looking at a 15-year sentence if you violate, the citizen doesn't know when it's okay. And it's not like with mental health, you can go get a psychologist to say you're okay and file something. And in the few states that follow the restoration procedure, they can get their gun rights back. The substance user can't do that. Yes.
I think Judge Quattlebaum has, go ahead.
I know we're way over, but
I know.
that's okay. We've asked questions. Is there a fundamental issue about whether constitutionally protected conduct applies at sentencing? We talked about that in our order for supplemental briefing. And the example that was in there, I think, was the acceptance of responsibility. And you made, I thought, a fair point about that's a waived situation. But it seems like from looking at circuit law that First Amendment protected conduct can be considered at sentencing.
Only when it's relative to the statutory factors.
Well, yeah, only
One.
when it's relevant. That's right.
And
But
two, Beckles says we can.
excuse me.
Beckles says the guidelines at sentencing are still subject to constitutional scrutiny. It rejected the void for vagueness challenge under the Due Process Clause. It did it because prior to the Sentencing Reform Act, district judges had unfettered discretion as long as they were within the statutory range to impose a sentence. So when the guidelines constrict that discretion, void for vagueness really didn't do anything new with that, as long as you were within the statutory range.
So if conduct that is protected by the First Amendment can be considered, and I think the law is if it's relevant. The government points out that evidence that violates the Fifth and the Fourth Amendment can be considered. I wonder, and I grant you that you read Bruin, and I get the logic that Bruin, that you could say increase in someone's sentence, is something that, is infringes, or, so I get that argument. But I'm struggling with the notion of First Amendment protected conduct and other conduct that is constitutionally protected being used, and wonder, even though whether that is appropriate to consider at sentencing, even though it might not be if that was the charge of conviction.
I address the Fourth and Fifth Amendment prophylactic rules, which this court has consistently held do not apply at sentencing, by nature of them being a prophylactic rule instead of a statutory prohibition in the amendment. That, to me, I got to work with it as defense attorney, but that was a conceptually significant distinction.
And it's a trial right, so
Correct.
maybe it's
Correct.
different. I mean, but there's
So-
First Amendment cases all over the place, and the Second Amendment, the Supreme Court ties the Second and the First together a lot.
It does, but it's not uniform, and I guess you've got U.S. v. Stewart from the Second Circuit in 2012, and U.S. v. Alvarez-Nunez, which is First Circuit from 2016. They discuss the standard and how that applies, and I would use the example, I forget which one is the 9/11 case, but it was a defendant, I guess that was a Second Circuit case, who went out and spoke about how her prosecution was trivial, it was trumped up, it was racist. She was entitled to say those things, but the court did consider her statements, and either enhancing the sentence or denying her acceptance because it didn't show contrition. And that was tied in really tight with the statutory factors you can consider, which would be the personal history and circumstances going through 3553A. This case and this issue is before we get to 3553A. It's not just compartmentalizing for the sake of it. Gall says those have to be calculated correctly. And my position is, had it been calculated correctly, not just B1, but under A, without considering the status, that would have gone in with a lower recommended range as he then considered whatever was considerable under 3553A. My hunch is my client would have gotten a shorter sentence, maybe not materially so, but easily another year off. And that's where we have the unreasonableness standard of not calculating the guidelines correctly. Based on what? Based on G3 being unconstitutional. Again, it's the status that enhanced it, not just the fact of drug use, but that it fit the status under the Gun Control Act that in our position and in Alston from North Carolina, we think shows violates the Second Amendment. The historical analogs just don't support the legitimacy of that status for permanent disarmament. You don't have the same how and why. Are there analogs to discuss? Yes, but they don't meet the well-established and representative historical tradition, even as a relevantly similar tradition, that would carry the government's burden of proof under Bruin. And that's where with step one, it's so important for the panel. Again, even if I lose, to acknowledge and rule, not assume without deciding, which was kind of the ongoing practice for 14 years, that my client is part of the people who enjoys those protections. So then we have to focus on the real active part. Bruin narrowed step one from what we did with Chester to a very simple question of conduct. And everybody has just argued back and forth, no, it means more and more. We're defining the conduct as who's trying to exercise it. That's not what it says. And that's crucial here. So I'm way over, and I apologize to counsel and to the court.
Thank you, Mr.
Thank you.
Coleman. Mr. Adams?
May it please the court. Troy Adams for the United States. At sentencing, the appellant requested a 36-month prison sentence, characterizing such as fair punishment, and that's exactly what he received. The district court underscored the appellant's high culpability, deserving punishment for possession of 10 NFA weapons, but noted additional enhancement factors unfairly ran the guideline range up. If base offense level and enhancement objections had been decided in the appellant's favor, his total offense level would be 19, with a criminal history category of 1 effectuating a 30 to 37-month advisory range. The 36-month downward variance requested and received falls within that range and is presumptively reasonable. Therefore, any error in sentence calculation is inconsequential and harmless. This case can alternatively be decided on other than constitutional grounds because the appellant did not challenge his NFA weapon conviction or enhancement based thereon. He therefore concedes the firearm-related portion of his base offense level enhancement. All that remains there then to challenge is the enhancement's consideration of his unlawful drug use, which is a personal characteristic of the appellant that does not implicate Second Amendment protection. Therefore, the appellant's sentence should be affirmed. I would welcome any questions the court has.
So you think that Bruin doesn't apply at all here?
I think Bruin could apply, but under Ashwander, I believe if there is a way to resolve this case without touching on the constitutional question, that's how the court should proceed. And I believe there are various ways in which this could be ruled on other than the constitutional question, one being the assumed harmless error inquiry, one being the fact as the court had brought up during the appellant's presentation that he does not challenge the NFA weapon conviction. Therefore, his enhancement under the base offense level doesn't raise a Second Amendment issue. It just goes to the second part, which is the personal characteristic, that being the unlawful use of controlled substances. Also, the reference to prohibited person is a reference in the enhancement under 2K2.1 A4B to 922G as a whole. The appellant tries to limit that consideration to just G3, but the reference is actually describing 922G as a whole, which would include 9 different categories of persons that would be prohibited from possessing firearms. And in this instance, based on Rahimi, G8 has already been found constitutional. And before this court in Canada, G1 has been constitutional. So therefore, there's already 2 circumstances under which if a person had a Glock switch and then, or was in that same 2K2.1 A4B, there would already be instances where it has been found constitutional.
But why are we, it seems like, maybe I must just be missing this, but we're looking at whether there is an as-applied 922G3 constitutional violation, and 922G3 as a statute hasn't been applied to Mr. Simmons, it seems to me. What's been applied under this enhancement is a portion of that, who's a prohibited person, and then that has been taken out of, picked up and taken out of 922G and married up with the NFA. So we don't, I mean, we're to be sure, we're using language from 922G, the unlawful user language, but there's not a conviction of that. There's not an enhancement for violating it. They're using that definition and applying it to the NFA possession.
Yes, that's correct, Judge. And that same argument was made by the government at sentencing and actually is the basis on which the district court did rule. It found a distinction between consideration of 922G3 for purpose of conviction, which, as the court is aware, the appellant wasn't convicted of 922G, was not charged with 922G in this, or 922G3 in this case. A distinction between that conviction and just consideration of a conduct that being unlawful use of controlled substances in the context of sentencing enhancement.
That's a distinction without a difference, isn't it? Who cares whether it's a conviction or enhancement? The question is, you're going to be incarcerated. And his status was used to enhance his incarceration, right? And through an enhancement.
Judge,
that implicates constitutional question. That you say, oh no, this is not conviction, this is just an enhancement. Both of them put you in prison for a long time. So you can't just pair off and say, well, no, it's not a conviction. It's the status made a difference here. And the status you're saying because that he's a drug user. That it makes him more, you got to show dangerousness, doesn't it? Isn't that the whole idea? Or is it just the status that you use drugs?
well, with respect to dangerousness and that related to unlawful drug use, this court in Carter 1 and Carter 2, 2012 and 2014, drew a correlation between unlawful drug use and dangerousness, basing that on common sense and on empirical evidence, noting that unlawful drug use requires that unlawful drug user to have contact with drug traffickers, which can create a dangerous situation in and of itself, but draws those individuals into black markets in order to obtain unlawful or illegal substances, and then also increases the likelihood of potentially violent interactions with law enforcement. So there is a correlation, not necessarily a causation, but a correlation that's already been drawn by this court between unlawful drug use and dangerousness.
But here's because it's associated with possessing guns, right? That's the status.
Correct.
Right, so you can't get away from the constitutional question whether or not a person who, according to the Supreme Court, you have a right to possess and bear arms. In terms of its step 1, right? And you should be punished, whether by conviction or enhancement, because of you exercise that constitutional right. Why is that so, why is that different because it's not a conviction? It's the same thing. An enhancement is you go into prison longer because you exercise a constitutional right.
It's the, excuse me, it's the government's position that the constitutional right isn't raised here because, as I pointed out, the actual firearm offense is conceded. That the appellant doesn't challenge the constitutionality of the actual firearm offense for which he was brought into that sentencing guideline enhancement to start with, that being the possession of the NFA firearm.
But the possession alone is not enough. It's the status of being the drug user that makes the enhancement work. Is that right?
Well, and that is a characteristic of the defendant.
A
that's
characteristic that has to work in conjunction with possession of a firearm.
So the firearm is considered within separate. That if there was not unlawful use and the appellant was being sentenced within the guidelines for possession of a NFA firearm that has not been registered, he would be at a base offense level 18. What brings him to the base offense level 20 that the district court calculated was the additional characteristic of unlawful drug use.
I know it is. What you call it a characteristic, I say it's a status, for example, at this point, right here. That's what they argue. It's a status. You need, even if you call it characteristic, it requires both the possession and the characteristic. You agree with that?
Yes.
And if that characteristic implicates a status in terms of prohibiting possession of a weapon, then that does, you can't get around Bruin by saying, well, it's not a conviction, but it is. It's the same thing. I mean, that's the essence of governmental control, is to put you in prison and put you there longer, because you have a characteristic that happens to be covered under the Second Amendment, perhaps. And that's what, Heller's, it changed, it was seismic. Bruin, seismic. I mean, that's what it's saying. And then it says that unless you're saying, we the people, unless you're saying he doesn't fall in we the people, and Supreme Court is not going that far, don't you have to then get to the second step to find a historical analog? Just because someone is using drugs, a lot of people use drugs and they function and do all kinds of things. And so, I mean, they're dangerous because they're using drugs? They could be, but just because of that, and therefore they can't have a weapon?
I believe there is a correlation between unlawful drug use and dangerousness, as I pointed out in the.
Oh, really? Just because you, by the way, so you're saying that if a person smokes marijuana and then they're dangerous to whom?
Dangerous to themselves and to others.
They smoke a joint and they're dangerous to themselves?
So in order to.
No, I'm just trying, it says user. You smoke a joint, you're dangerous to yourself? Mind you, this is a place that where, many states that this is not even illegal. In Virginia, my home state, simple possession, that kind of, so that you said is automatically dangerous?
So certain drugs would certainly have different effects on different individuals. And in order to even be brought into that unlawful user category, it would require more than just the.
So 923 says it has to be what? It can't be marijuana, right?
No, not that it can't be marijuana.
I think, no, it doesn't say that at all. It doesn't. It's just so that's why I use marijuana. It's so marijuana, you smoke a joint, then you are dangerous, per se.
The way that an individual is brought into unlawful user category would be that use has to be consistent and prolonged and simultaneous with the gun possession. So I'm not sure.
Was he intoxicated when he was arrested?
At sentencing, the government.
Are you going to answer my question or are you just going to go on? I said, was he intoxicated when he was arrested?
The pretrial services report that was drafted at the time of his arrest, at the time he was found in possession of the 43 firearms, including the 10 NFA weapons, showed that he tested positive on that date for methamphetamine and marijuana.
That he had used it?
That would be an indication that he had used, that's correct. So
use and intoxication is the same thing, just he used it. So you're saying that the fact that he used it makes him intoxicated. Like for example, like driving under the influence, drinking one drink doesn't make it illegal to drive, does it? It doesn't have to be a level, of course,
It does.
right, of impairment. But you're saying using a drug makes you dangerous, period.
Correct. There can be a distinction between unlawful use and intoxication, but the government's argument is that it's not necessarily the intoxication alone that makes an unlawful user dangerous. It's the lifestyle that comes along with unlawful use. And that, as I pointed out, the various characteristics of an unlawful user pointed out in Carter, the interaction with drug traffickers, the interaction in black markets to obtain their controlled substances. And then again, the heightened chance of violent confrontational interaction with law enforcement. So it's not just the intoxication alone.
But as
Certainly-
applied to him, you don't have those facts here that he was a drug trafficker, do you?
No, Your Honor.
No, you don't. That's why it's an as applied challenge.
Well, and the correlation to dangerousness isn't just limited to a drug trafficker. That would apply to a drug user. That's what
That's
was,
what I'm saying. It goes back to just using drugs is enough, as you said, to make you dangerous. But that's enough to get you a higher sentence for exercising a constitutional right to bear arms. That's important, isn't it? I mean, you certainly couldn't have something that gave you a higher sentence because you practice a certain religion in the First Amendment, could you?
I'm sorry, I don't know if I...
You couldn't have an enhancement that gave you more time, not a conviction, but enhancement because it's based on the religion you practice.
Well, we would have...
You couldn't, could you? You couldn't.
No.
And that's the First Amendment, isn't it?
Correct.
Oh, okay.
So, well...
But the Second Amendment would be different. The Second Amendment would be different. Matter, I'm talking about, I'm following the Supreme Court now, and that's not me. That's why they're saying, Heller says it is a quintessential element of a handgun to have it for your protection. And then Bruin says, no, it's beyond just the home. This is what it said. And more importantly, you can't even use, means and ends in terms of limiting it. You got to find an historical analog. It was meant, to me, step one was not meant to be a heavy lift, unless you start getting into things like women couldn't vote, or African Americans were enslaved and they're not the people. Unless you want to go there, nobody's gone there. So other than that, if you're a person, you're entitled to have Second Amendment rights. And don't you, unless you said the weapon is something that's out of the mainstream, then you go to second step two, and you have, the burden is on you. Isn't it? Do you agree that the burden is on you?
Yes, Your Honor. With respect to the Bruin analysis, it's still the government's position that as a unlawful user of controlled substances, the appellant is not a law-abiding citizen and therefore is not part of the people. But even if the court doesn't...
So you're going beyond Rahimi and everything, right? So you're going to, right? You're going beyond Rahimi.
Rahimi addressed the term...
It's territory that the Supreme Court didn't go into. But go ahead. Go ahead. I'll make your argument.
Just pointing out, the Rahimi court described reasonable as vague, but didn't touch on law-abiding. But even if the court would not rule based on the step one, the textual part of the Bruin analysis, it's the government's argument that there are sufficient historical analogs to support the step two. And
before you get there, counsel, I want to talk about B1. B1 seems to increase the offense level by various points based on the number of firearms involved in the offense. And the offense, as I understand it here, is possession of NFA firearms without being registered. Is that correct?
the offense is, the offense of conviction would be the possession of the NFA weapon.
Right.
It is the government's understanding of the enhancement under B1 that that would include all firearms that are unlawfully possessed by the appellant. The commentary note to B1 states it includes all weapons that are unlawfully possessed, which as an unlawful user, he would not be able to possess the NFA weapons or the other 33 weapons that were seized from his home.
It just seems to me that it says the offense. I mean, it's singular. And the only offense in this case is an NFA weapon. It seems to me, or I mean, I guess that's your argument that that we talk about offense that he hasn't even been charged with for this an enhancement. I just doesn't. I'm having trouble making that. Yeah, if you look at most of the cases that are applying B1, they are dealing with 922G3 type weapons, but this is different. This is different than I think any case out there. And here our possession is an NFA weapon, which probably under Bianchi isn't protected by the Second Amendment. I just don't see how you can read offense to be something other than the offense he's charged with.
Your Honor, it's the government's understanding that B1 would take into account all relevant conduct, which would include all firearms that he had in his possession at that time.
Well, that's a separate argument. You might be able, relevant conduct is one thing. I mean, the sentencing talks about relevant conduct. And if you wanted to say, relevant conduct there, then I think that frames, what, maybe more, what your colleague is arguing. But I don't see how B1 applying it according to its text can apply to the offense to anything other than the NFA offense. That's the only offense in this case.
The government understands the court's
You
interpretation.
just disagree.
Just disagree, and referring to the commentary that tries to describe that further, and that it pointing out that it includes all firearms that were unlawfully possessed.
Does the government feel like that issue is something that's before the court and properly preserved and something we can just, who knows whether we'll be convinced by it, but is that a, preserved issue for us to consider?
The B1 issue?
Yeah, the issue I'm pressing you on whether it includes possession of weapons or guns that are not the NFA offense.
I don't recall that argument being raised by the appellant.
But it's a necessary predicate to see whether, we have a constitutional issue, isn't it?
It would be. Yes.
And if, if hypothetically I'm right, it would make sense not to decide a constitutional issue if there's an error in calculation that doesn't get us there.
Ashwander would direct that, yes. Apologize, I'm out of time. If there are no further questions, I would just ask the court to affirm the district court's sentence.
Thank you, counsel. Ms. Adams. Mr. Coleman, you have some time reserved.
Try to use it quickly in light of your indulgence earlier. The questions about dangerousness and drugs. Colorado and Washington were the first states to legalize marijuana in 2012. In FY 2024, we now have 24 states that have legalized it recreationally.
This isn't a case about marijuana. Can we get away from the marijuana conversation and move on to the question of the methamphetamine use?
They were both, Your Honor. That was my point. But
Yeah,
Okay,
I'm not
let's
denying
just,
that wasn't marijuana? Yeah, I thought so too.
yes, sir, you had 14 approved for medical use.
Yeah.
7 sell CBD oil only. We're down to 4 jurisdictions now. Idaho,
didn't
Wyoming,
the
Nebraska, and
district
South.
court, didn't the district court speak about the methamphetamine use?
Yes, ma'am. I believed he focused on both. That was a statement, and that's what they found with the warrant. And it was a nominal
Right.
use.
And that's what he was penalized for, right?
The drug use generally, yes, ma'am, as noted in the PSR.
I know you've been.
I'm not disputing any of that, sir.
I know you're being respectful, but it's yes, Your Honor.
I'm sorry.
You said ma'am.
Oh, yes, Your Honor.
Yeah,
Thank you.
go ahead.
The Sentencing Commission has a quick facts resource, some I've cited too in sentencing memos. Even after Rehafe and Justice Alito's prediction that adding a scienter requirement would make it impossible to prosecute 922G1 cases, There were 7,600 the same year in 2019 when rehafe was decided. By 2024, we were back up to 8,040. 165 of these defendants were NFA sentenced. There were 2,400 as prohibited persons under at a base offense level 14. The rest of those were primarily made up of almost 88% G1 cases, at least last year. Mr. Adams answered your question about dangerousness going back to Carter. I argued both the Carter cases, and just Judge Niemeyer's resort to empirical evidence, drug use, who they hung out with, access to black markets. That was all part of means and scrutiny and seeing whether there was governmental interest to justify the prohibition. There are no historical analogs based on any of this. In fact, the founders did not strip regular users of intoxicants of their fundamental rights regardless. So, Judge Quattlebaum, Your Honor, I need to address the dangerousness with your question, and I guess I was perplexed earlier. It does say offense in 2K2B1, but I always have to go back to 1B1I defining offense, and that has the offense of conviction plus relevant conduct defining the use of offense in the guidelines. So to answer your question, and I should have done this earlier, I had looked during the break, I don't think you can avoid the constitutional issue just by looking at that with B1 with the offense. I don't believe that with the constitutional issue, the non-NFA guns were relevant conduct. That's part of the objection to the G3. Otherwise, if they were, then I really don't have an issue with the calculation and that two-level enhancement between the 4 and the 6 for the number of guns. So I think we do have to focus on the constitutional issue and decide that. And I agree with Judge Gregory, bringing over just the definition doesn't insulate it from lack of a constitutional challenge. You don't need a conviction for that. Just like you don't need a conviction to be guilty of G3.
Yeah, I understand the point on B1. I guess my point is certainly the use of status raises questions, but the use of status combined with a weapon that's not protected, I'm not sure creates Second Amendment problems.
It's much less there than it would be with weapons he could possess if he didn't have the status. That's my argument, at least.
And I get your argument that if it's in B1, yeah, if non-FAA, I think your point is that if non-FAA weapons are used in B1, yeah, we have that situation there. Yeah, I may disagree based on the application, but I understand your argument.
Thank you.
Thank you, Mr. Coleman. Any
Thank
further
you.
questions? All right. I want to thank both counsel. I'm going to ask clerk to adjourn the court, sine die, and then we'll come down and greet counsel.
This honorable court stands adjourned, sine die. God save the United States and this honorable court.